Once you've selected which entity you would like to form, then you have to go through the formation process. Let's discuss the formation process for a corporation. First, what you do is you submit articles of incorporation to the Secretary of State along with a fee. Incorporation, right, the creation of the corporation occurs when the Secretary of State files your articles of incorporation. You will receive a notice from the Secretary of State when that happens. Then you engage in certain post-incorporation formalities. There are several formalities that you have to do, that you have to engage in. These are the most important. Remember, the default for the corporation is that there will be centralized management, and that means a board of directors. Once you have incorporated, you have to appoint or elect the board of directors. A corporation will also usually have officers, such as the secretary, the treasurer, and the president. We will have to appoint officers at this stage. A corporation will also have bylaws. We'll discuss what the content of the bylaws should be later in the course. But for now, let's understand that at this point, we have to draft and adopt the bylaws. And finally, we need money and we need shareholders, do we not? That's where we're going to get our money from. So we have to issue stock. These are the four most important post-incorporation activities or formalities that we need to go through. All right, let's look in detail at articles of incorporation. Remember, to incorporate your corporation, you have to send articles of incorporation to the Secretary of State, and then the Secretary of State will approve them and file them. At that point, you have given life to a legal person. Sometimes, in some jurisdictions, the articles of incorporation are referred to as the certificate of incorporation or the charter. Throughout this course, we'll call them the articles of incorporation. Now, the articles of incorporation can be really very simple, only 4 or 5 very simple articles. More sophisticated articles of incorporation can be dozens of pages long. Later in the course, we'll look at some more sophisticated examples of articles of incorporation. For now, let's stick to the most simplest example. Let's go through the articles of incorporation in detail. Let's just take a quick look at the articles of incorporation. This is the form that you can find on the Secretary of State website for the Commonwealth of Kentucky. You can find similar forms on other Secretary of State websites. You can see that it's fairly easy to fill out. On the back, you'll find these helpful instructions. This is a similar form that you can find on the Secretary of State website for Ohio. All right, so the first thing we want to look at is the name of the corporation, right? It seems like something that's pretty simple to fill out, but you have to know the limitations and you have to know the basic rules for selecting a corporation's name. Let's discuss some important aspects about selecting the name of the corporation. First, you should know that the name of the corporation does not necessarily have to be the same as the corporation's brand or trademark. Here's a famous example. Have you heard of this corporation? Kimberly-Clark Corporation. It's a large public corporation with business around the world. Well, you may not have heard of the name of the corporation, but you definitely have heard of the brand Kleenex, which is one of its products and one of its brands. As far as the Secretary of State is concerned, the name of your corporation must have a specific suffix, and any one of these will do. Corporations, incorporated, limited or company, or it could be an abbreviation of one of those, Corp, Inc., Ltd, or Co. This signals to everyone that this is a limited liability entity. If you're doing business with us, you cannot try to recover from our owners. Our owners enjoy limited liability protection. The second important thing that the Secretary of State is concerned with is that your name, the corporation's name, must be distinguishable from any other name on record. Now, if you go to the website of the Secretary of State of your state, there will generally be a name availability search tool, and you will put in the name that you want and you will see if it is available. And there will be certain rules that you can usually find on the website to determine whether your name is sufficiently distinguishable from any other name of record with the Secretary of State. The whole idea is that the name of your corporation cannot be similar to a name of a current LLC, corporation, partnership, etc. Now, even though a name may be available, your client still wants to be careful about not infringing on someone's trademark. So, for example, in my jurisdiction, I might want to call the corporation the Kleenex Corp. And I do a name search, and that name might not be taken in my jurisdiction. It might be available to use as a name of a corporation in my jurisdiction. However, if I use that name with my corporation, I will probably be infringing on Kimberly-Clark's trademark Kleenex, and I will most likely get a cease and desist letter from Kimberly-Clark telling me that I cannot use that name. You want to avoid those problems. So don't just do a name availability search on the Secretary of State website. Do other searches to see if there is someone using that name in some other jurisdiction, or if someone is using that name as a trademark or a brand name. This will avoid trouble down the road for your client. The next item we want to look at is the number of authorized shares. This is called authorized shares, authorized stock, or authorized capital. Remember, a corporation will issue stock to its investors, and those investors then become stockholders or shareholders. How many shares of stock will the corporation have that it can issue to its potential investors? This is called authorized stock or authorized shares. Here's the Ohio Secretary of State form, and you can see it has the same thing. Number of shares. We'll talk about type and par value a little bit later, but let's focus on the number of authorized shares. Let's try to understand what authorized shares are. Now, remember, our business entity is going to raise capital, at least initially, by issuing and selling shares to the owners. And once an investor buys shares, that investor becomes a shareholder or a stockholder, right? This person is now an owner or equity investor or residual claimant of the corporation. So authorized shares are important. If we don't have any shares authorized, we won't be able to issue any shares to investors in exchange for the capital that we need. The authorized shares is just the number of shares the corporation may issue to investors, may sell to investors in exchange for the capital that we need. It may and is usually different from the number of shares the corporation has actually issued. So here's an example. Maybe our corporation has 10,000 shares of common stock authorized in its articles of incorporation. But in reality, it has only issued 4,000 shares. So we would say that the company has 10,000 shares of common stock authorized, and issued and outstanding, it has 4,000 shares of common issued and outstanding. That means it can still issue another 6,000 shares. If it issues the full 10,000 and it needs to issue more shares, it will have to amend its articles of incorporation. You might be asking a question, well, if I'm going to draft an articles of incorporation, how many authorized shares should I put in here? Well, it really depends on the needs of the business entity and the needs of your clients. If you're going to just have one shareholder, then maybe you only need one share, or maybe you need 10,000 shares and you'll issue all 10,000 shares to your investor. But be careful. Some jurisdictions, the fee the Secretary of the State will charge to file the articles of incorporation might be based on the number of authorized shares you put in the articles of incorporation, in which case it behooves you to put in as low a number as possible. In Kentucky, how many authorized shares should you have? Well, really depends on what your client needs, but generally your client can do whatever he or she wants with 100 shares or 50 shares or 500 shares. So you don't really need a lot of shares. In addition, look down here at the filing fee. So it's going to cost you $40 flat out to file the articles of incorporation. Then there's an additional organization tax fee. If you have 1,000 or fewer authorized shares, that organization tax fee is only $10. So if you're setting up a Kentucky corporation for your client, you should consider having 1,000 or fewer authorized shares. Okay, now let's look at the next topic. And for the next topic, I want to look at the Ohio form. Look down here. It talks about type of stock, type of shares. Let's discuss that in a little bit more detail. Let's talk about the different classes of stock that you might draft into articles of incorporation. The two main classes of stock or types of stock are common and preferred. You're not limited to those designations. Heck, you can call a class of stock Mary if you want, but most people use common and preferred. That is the typical scenario that you're going to see in closely held businesses and even large public companies. So what is the common stock? Well, the common stock is the default stock. The common stock just generally has the residual economic rights and the control rights that shareholders have. We'll learn what control rights shareholders have in a later chapter, but just now think of the common stock as the stock that votes and the stock that has the residual claim. If you have a preferred stock, well, the preferred stock is going to have some sort of economic right superior to that of the common stock. So for example, your preferred stock might have a right to receive a dividend before the common stock receives a dividend, or it might have a right to receive a higher dividend than the common stock. Preferred stock might have preferred voting rights, so you can draft it any way you want. Generally, when we're seeing preferred stock in a large public corporation, the preferred stock will not have voting rights. And we'll discuss that in more detail in a later section. If we're a business entity at an early stage and we get investment from venture capitalists, the venture capitalists might take preferred stock, and their preferred stock is going to have economic rights superior to the common stock of the founders of the business, And they will usually, not always, there's lots of different ways to draft this, but they'll usually have voting rights that are superior. So there's lots of different ways to draft preferred stock. We're just drafting simple articles of incorporation now. If you have different classes of stock, you do not have simple articles of incorporation. Once you have different classes of stock, now you have to draft details, articles of incorporation, explaining and describing how these classes of stock differ from each other. Once again, as I said, the default is common stock. If you draft articles of incorporation and you don't say whether your stock is common stock or preferred stock, or you don't make differentiations between classes, then all of your stock is common stock. It's just a name for regular stock. And most people think, when they think of stock in a corporation, they think of common stock. If you look at the Kentucky form articles of incorporation, right here in Article 2, where we're supposed to put the authorized shares, it doesn't give us any space to put the type of shares or the class of shares. If we want to have common and preferred, there is no place to write that in. So does that mean we can't have different classes of shares in Kentucky? And the answer is no. We can, we may, we are allowed to have different classes of shares in Kentucky. So what am I to do? Well, let's look at the instructions which are on the back of the form. So here it says, the articles of incorporation shall prescribe the classes of shares. All right, and the number of the shares of each class. So we can have different classes. We can have common and preferred, or whatever different classes of shares your client wants. But if we do that, look here, we cannot use this form. We have to draft the articles of incorporation out ourselves and then send that into the Secretary of State. All right, so in Ohio, we can write in the type of stock, and that's just the different classes, common, preferred, etc. But keep in mind that if you have different classes of stock, the articles of incorporation must describe how they are different, what preferences the preferred will have, etc. And if you do that, just like in Kentucky, you cannot use this form, or you can use this form. In Ohio, you can use this form, but you have to have some sort of attachment to this form. And it's probably easier just to draft the entire form out yourself. Have your own draft articles of incorporation and not use this form if you're going to have different classes of shares. Let's look at the next topic. And for this, we're going to continue looking at the form for the Ohio Articles of Incorporation. Look, you can put par value of the stock, par value of the shares. What does that mean? Well, let's talk about that in a little bit more detail. Let's talk about par value. Students often have trouble understanding par value, and I think it's because they try too hard to understand it. There's not really a lot to understand. Par value is an arbitrary value of the shares. It is not the market value of the shares. When a corporation issues stock to investors, it may not receive less than par value. So for example, here's an illustration. Let's imagine that our corporation has 10,000 shares of common stock that is authorized, and the par value of the stock is $1 per share. Now the corporation issues 1,000 shares to investor. When the corporation issues these 1,000 shares to investor, the corporation must receive at least $1,000 from the investor. That's all par value is. And you might say, well, how did you establish the $1 par value? And the answer is, it was arbitrary. The board of directors said $1. Or when we were drafting the Articles of Incorporation, we said, what should the par value be? And someone said, I don't know, $1? And everyone said, okay. That's all it is. That's all it is. Okay? I have seen par values this low, and I don't even know how to express that. That's just less than a penny, right? It's such an infinitesimal amount. Sometimes par values are just that low. So in a jurisdiction that requires par value, remember what limitation this has on your corporation. If a corporation issues shares, it cannot receive consideration less than the par value for those shares. And that's why you would have a very low par value. So you wouldn't run the risk of selling shares below that par value. In some jurisdictions, par value is required, and then you would generally see a par value that is ridiculously low, like our example here. In Delaware, par value is not required, but your taxes, the fees you pay, can be cheaper if you have par value. So you can, in Delaware, you can have no par value stock and par value stock. But the way they calculate your franchise taxes, it could be cheaper for you to have par value stock, but just have a par value of very infinitesimal value. So that's all par value is. Don't get overly excited about trying to understand it. It's arbitrary. It's largely a dinosaur and not very useful, but some jurisdictions still require, and you still see it. Sometimes you'll see par value, and you just have to understand what that means. All right, you'll see that the Kentucky form doesn't give us any space to write what the par value is. You should not write it in here. In Kentucky, you do not have to have par value for your stock, but if you do, if you want it, you may. Right? If you do have par value, then you cannot use this form. You have to draft out the Articles of Incorporation wholesale on your own. All right, so related to par value, the Ohio form has this. If the corporation is to have an initial stated capital, please state the amount of that stated capital. So par value and stated capital are related. Par value is the par value per share. So if we have a $1 par value, that is the par value per share. If we have 1,000 shares issued and outstanding, the stated capital would be $1,000. You get it? So par value is the value, par value per share. Stated capital is all the par value added up. And that's only for issued and outstanding shares. So in our Articles of Incorporation, if we want to have an initial stated capital, please state the amount of that stated capital. So here's an example. Let's say we put in par value per share $1. And then in the fourth article where it says initial stated capital, we put $1,000. That means before we start operating our corporation, before we start operating our business, we have to receive $1,000 in investment from investors who then become stockholders. You get the idea? So for us, that means we would have to issue 1,000 shares before we started our business, right? But only if we fill in this form. Only if we fill in the fourth item of this form, initial stated capital. You do not have to have an initial stated capital. So once again, reviewing, par value is per share. Stated capital is all of the shares that you have issued and it's outstanding add up the par value of all of them together, and that will be the initial stated capital. So for example, if the par value is $1 per share, and we have 1,000 shares issued and outstanding, then our stated capital is $1,000. If we fill out this item number 4, and we have an initial stated capital of, say, 500, then we have to issue 500 shares and get $500 from our investors before we can begin operating our business. Once again, this 4th item, initial stated capital, is optional. What exactly is an initial registered agent? Well, simply put, it is the agent to receive process on behalf of the corporation. If someone wants to sue the corporation, they have to know on whom they should serve process. And this is the initial registered agent. If someone wants to sue the corporation, they will go and they will check the Articles of Incorporation, which is on file with the Secretary of State, and you can access that through the Secretary of State website. They'll see who the agent, the initial registered agent is, and they will see the address of that agent, and they will go there to serve process on the corporation by serving process on the agent. The initial registered agent is not a general agent of the corporation. It cannot represent or bind the corporation in any other way. The purpose of the initial registered agent is really limited. It's only to receive process on behalf of the corporation. Looking at the Kentucky form for the Articles of Incorporation, you'll see that here and here is where you put the street address of the corporation's initial registered office and the registered agent at that office. That's where you put the name. Your headquarters don't have to be the registered office. The registered office is just what it is. It's a registered office in Kentucky. There are companies that do this professionally. They act as your registered office, and they will also act as your registered agent if you so choose. So if you think that to set up a corporation in Kentucky, that you must have your headquarters in Kentucky and that you must have your president in Kentucky, that's not what it means. You can set up a corporation in Kentucky and have your headquarters and your business operations in some other state, but you need to have you need to have a registered agent and a registered office within the state, and there are companies that will do this for you professionally. Here is where this is down further on the form. This is where you print the name of the registered agent. You see that the registered agent is signing this to consent to serve as registered agent. If you draft your own Articles of Incorporation and you don't use the Kentucky form, you still have to be careful to make sure that you have a consent from the person who's going to act as the registered agent. And there's another form for it. So if you're drafting up your own Articles of Incorporation, here's the form. If you're using the Kentucky Articles of Incorporation form, at the bottom there is a place for the registered agent to consent and sign. But if you are drafting up your own Articles of Incorporation, you have to make sure that you make sure to have another form where the registered agent consents to act as the registered agent. The Kentucky form also has a place for the mailing address of the corporation's principal office. This can be an address that is in Kentucky or outside of company. This is not the registered office. This is just where the Secretary of State will send notices if the corporation wants it to go to someone other than the registered agent or to the registered office. So if your headquarters are outside of the state, you might put that address here. If your registered office is the same as the principal office, then you just repeat your registered office here. Just taking a quick look at the Ohio form. The Ohio form only has one address, location of principal office in Ohio. This is equivalent to the registered office in Kentucky. The Ohio form does not have another address line, so if your headquarters are out of state, you have to rely on the address in Ohio to receive communications from the Ohio Secretary of State. What is an incorporator? Well, an incorporator is just the person or persons who submit the articles of incorporation to the Secretary of State for the Secretary of State to file. It is often the attorney. So you will often act as the incorporator when you are helping your client set up a corporation. The incorporator might have some simple tasks that she needs to do once we have received notice from the Secretary of State that the Secretary of State has filed the articles of incorporation. All right, so on the Kentucky form, this is where you would fill out the information about the incorporator or the incorporators. And further down on the form, this is where the incorporator would sign. Let's talk about corporate purpose in the articles of incorporation. Some form articles of incorporation, especially those that you might find on the Secretary of State's website, will have a place where you can write in the purpose of the corporation. It is optional in most jurisdictions, and where it is optional, you should either leave it blank or just put in a broad statement, something like any lawful act or activity. And there's boilerplate language for you to put in there. But once again, it's important that you either leave it blank or put in a broad statement, unless there is really a special limited purpose for this corporation. So if this corporation was solely formed to buy a specific piece of property and operate that piece of property, that piece of commercial property, and lease it out, then you should put that in the articles of incorporation. Otherwise, leave it blank or put in just something simply, any lawful act or activity. Why should you leave it blank? Well, you run the risk of a doctrine called ultra vires. Ultra vires means, or sometimes people pronounce it ultra vires. Ultra vires just means that you have done something that is beyond your authority. And if the corporation does something that's beyond its authority, some of the shareholders might bring a lawsuit. There could be conflicts among the various shareholders or between the shareholders and the management. And so it just becomes a very sticky situation. So once again, if the corporate purpose is optional in your jurisdiction, you should just consider leaving it blank. Now, in some jurisdictions, it's mandatory. You must put in a corporate purpose. But even though in those jurisdictions, you're allowed to put a broad statement, any lawful act or activity. Finally, you can put other provisions in your articles of incorporation. We've gone through the most basic, the required provisions that you must have in your articles of incorporation, but there are other things that you may put in your articles of incorporation. Now, you might be thinking, well, what types of things will I see in articles of incorporation? What types of things should I put in the articles of incorporation that will best serve my client's interests? As we go through the rest of the course, we'll discuss these things in greater detail. For now, let's just get a basic idea of what types of things you should be anticipating will be in articles of incorporations that you might see and that we might discuss later in the course. First, let's get a grasp on the two major organizational documents of the corporation. The first major organizational document you're already aware of is the Articles of Incorporation. You know that this must be filed with the Secretary of State. The other major organizational document of the corporation are the bylaws. This will not be filed with the Secretary of State. This is an internal document used by the corporation only. Let's think of the Articles of Incorporation as analogous to the Constitution of the United States and the bylaws analogous to the statutory law of the United States. The Constitution, or the Articles of Incorporation, will have the most important provisions, the basic structure, the governance, and the rights of the shareholders and the directors. The Articles of Incorporation, like the Constitution, is more difficult to amend. We required shareholder approval to amend the Articles of Incorporation. And we saw as we went through the Secretary of State forms that if you want to amend the Articles of Incorporation, not only do you need shareholder approval, but you must file an Articles of Amendment with the Secretary of State. Now, there are certain provisions in the corporate law of your state where it's optional whether you want your corporation to have these provisions. If you have these provisions, you must put them in your Articles of Incorporation. Once again, as we go through the rest of the course, we'll run into these provisions, and they will clearly say that if the corporation wants these, they must be in the Articles of Incorporation. But here are some examples. If we want our corporation to have different classes of stock, like we've seen, such as common and preferred, we have to put that in the Articles of Incorporation. Later in the semester, we'll see an exculpation clause. An exculpation clause will exculpate our directors if they violate their fiduciary duties. In other words, they will not be liable for violating their fiduciary duties. This is a very important provision, and because it's so important, if the corporation elects to have an exculpation clause, it must be in the Articles of Incorporation. Other provisions that the parties feel are particularly important to their corporation, to their situation, they might request that these provisions be put in the Articles of Incorporation. Well, what about the bylaws? Well, the bylaws are easier to amend. They can be amended by either the board of directors or the shareholders. In the bylaws, you'll put simple voting provisions, internal governance provisions, meeting procedures, etc. Remember, if you are drafting Articles of Incorporation for a Kentucky corporation and you want to have provisions in your Articles of Incorporation that go beyond the basics, that go beyond the minimum requirement, then you can't use the Kentucky form. You must draft the Articles of Incorporation out wholesale. It's not hard. It's very easy, as a matter of fact. Most law firms do that anyway. In Ohio, you can still use the form, but you have to have an attachment. It's probably easier just for you to draft the entire Articles of Incorporation and not use the form. Once again, that's what most law firms do anyway.